Good afternoon and welcome to this afternoon's webinar. March 2022 is Mental Health Court Month, and as a result, we have a series of 3 webinars scheduled. And welcome to the first one, Mental Health Court Treatment and Legal Issues. Some housekeeping matters to address. The panelists who you can see on the screen are reminded to mute their microphones when they are not speaking and unmute it when they are about to speak. Also, we love to engage with you and have conversation with you. And the best way to do it is through a Q&A. We'll be monitoring that Q&A and would love to answer your questions. I know the panelists are dying to be questioned, and we'll be looking forward to answering your questions. So please use the Q&A. You can always check us out using our various social media handles, find out what is going on and what is planned and what interesting speakers are scheduled. Also, a recorded version of this webinar will always be available on the website at the end of this webinar. And we would like to thank the organizing committee. Jennifer Graham, Assistant Crown Attorney here in Peel, Andrew Rivard, Duty Counsel with Legal Aid Ontario, Kim Briggs is a professor at the University of Western Ontario, and Erin Smith is a crisis intervention specialist with the Canadian Mental Health Association, and also myself, Justice Kofi Barnes. We are your hosts, and we are glad you could join us. Before we do the land acknowledgement, I should also indicate to you that the views that I expressed today are the views of the panelists and not necessarily the views of the Association of Justice and Treatment Professionals and the International Association of Treatment Professionals. And also, we should say that we are always looking for new topics, looking for new speakers. Feel free to contact us at our website and give us information on anything you'd like to hear. I'm not going to introduce the panelists now, but Andre, why don't you do the land acknowledgement for now, and I'll stop sharing my screen.
Yes, thank you very, very much, Your Honor. And as you said, it's important for our group to make sure that we do a proper acknowledgement that, while we may be remote from our own different corners of the province and beyond, in general, we're meeting on Aboriginal land. And this is land that's been inhabited by the Indigenous people from the beginning. As settlers, we're grateful for the opportunity to meet and discuss here, gather here. There are generations of people that have taken care of this land for thousands of years. So long before today, there have been Aboriginal peoples who have been stewards of this land. In particular, it's important to acknowledge the Anishinaabe, the Huron-Wendat, the Haudenosaunee, the Ojibwe, Chippewa peoples, land that is home to the Métis, and most recently, the territory of the Mississaugas of the Credit First Nation. They are the direct descendants of the Mississaugas of the Credit. So we recognize and deeply appreciate the historic connection to the land. We recognize the contributions of Métis, Inuit, other Indigenous peoples, and those that have been shaped and helped strengthen the community in particular as we grow as a country. As settlers, this recognition of the contributions and historic importance of Indigenous people must also be clearly and overtly connected to our collective commitment to make the promise and the challenge of truth and reconciliation very real in our communities, particularly as we bring justice for the lives lost, residential school systems, as well as the missing and murdered Indigenous women and girls all across our country. So it's important that we reflect on that. With that, I'll hand it over to Jennifer Graham, Crown Attorney in the Peel office, who's going to help me to introduce our panelists today.
Thanks so much, Andre. I am so very pleased to have the honor and privilege of introducing our 3 panelists today, all very dear friends of mine, and fantastic, inspiring and powerful women in the field. And I'd be remiss if I didn't mention, I'm super pleased that it's the day after International Women's Day, that we're able to come together and have this discussion. It's too bad it wasn't yesterday, but nonetheless, we're very pleased to have them. So first we have Kim Briggs. She's a registered social worker who has spent 15 years on the front lines of the mental health and justice system. Kim has held several roles throughout her career, including probation and parole officer, crisis outreach counselor, and the majority of her time on the front lines was spent coordinating delivery of mental health court programs in Elgin County. Currently, Kim teaches forensic psychology at Western and Laurier universities. She is co-leading the development of an upcoming drug treatment court for Elgin County, and she is working toward her PhD in educational leadership. Kim believes in focusing on equity as a main tool to improve mental wellness in our communities. Next, we have Lucy Rasmussen, a colleague of mine at the Peel Crown Attorney's Office. She has been practicing law since 2005, where she was called to the bar of England and Wales. She worked as a civil and criminal barrister for several years before moving to Ontario. Since 2014, she has worked at the Peel Crown Attorney's Office. Currently, she is the mental health team lead, as well as being the designated elder abuse crown, and sits on numerous committees, including the HSJCC, MHJAC, and ARC, the Alternative Resolution Court. Additionally, she is a board member of the Alzheimer's Society of Peel. Lucy is passionate about trying to assist those involved in the criminal justice system who are particularly vulnerable and or marginalized. And last but certainly not least is Christine Lund. She is a lawyer practicing criminal law in Dufferin Peel. Her practice focuses on representing vulnerable adults and youth in the criminal justice system, as well as acting for complainants in sexual assault pretrial applications. Christine is the Peel Director of the Criminal Lawyers Association and has been a longtime member of the Brampton Courthouse Mental Health Committee, which is now known as Alternative Resolution Court. She believes in a client-centered collaborative approach to lawyering. She was also appointed as a member of the Ontario Review Board in 2020. So as you can see, we have these wonderful, diverse women who are hopefully, and I know they will, have an excellent presentation and panel for us. So take it away, ladies.
Thanks very much, Jennifer. And thank you everyone for joining us today to talk about mental health courts, which, as you probably all know, have popped up all over the country in response to some of the critiques of the revolving door of the criminal justice system, and recognition that traditional legal interventions have not been as effective as we would hope in reducing recidivism rates for people with mental health issues or other developmental challenges. And so therapeutic courts, community treatment courts, mental health courts, whatever you want to call them, were developed to provide holistic supports and treatments, while at the same time holding an accused accountable for their actions. But the intent is to provide proper as opposed to special attention for accused persons. All of the programs have different goals. Most have some similarities though, and all are hoping to ultimately reduce recidivism and decriminalize special needs individuals, moving away from the idea of criminalizing mental health and homelessness issues and providing different types of supports to individuals and also their families and others who are impacted and others who support the people that we work with in these community treatment courts. Most community treatment courts look to alternatives to custodial sentencing where it's appropriate. The research shows that putting people in custody is not all that effective at reducing criminal behavior in people with mental health challenges. And so we've started to look at other options and more effective options. And of course, the rights of the public, the accused, the victims, and anyone else that's involved in the case would be important, while at the same time maintaining the integrity of the criminal justice system. And ultimately, these programs work to reduce stigma and create awareness in our communities and an understanding towards mental health problems, and recognizing that different types of treatment might be a better option for somebody who's struggling with their mental health. Each program has different eligibility requirements. Most programs require at least symptomology of a mental health problem, developmental delay, or some places require a full diagnosis. My own opinion is that we should be looking at symptomology. There are all kinds of people out there who have never been officially diagnosed, and that's linked to stigma usually. People carry all kinds of shame, embarrassment, and people are hesitant to reach out to formal sources for support where they would receive that official diagnosis. So there's lots of people out there who have never been officially diagnosed, but who might be great candidates to participate in our programs. And we also want to see in those people, the people that we're looking at bringing in programs, we want to see an interest or a willingness to participate. And that's rooted in understanding stages of change and change being internally driven. With the right supports, somebody who's ready to connect to those supports can have quite a life-altering experience in a therapeutic court. And then, of course, you have legal eligibilities, and those usually are around the seriousness of the allegations. And most community treatment courts look for a nexus, so a connection between the mental health problem and the crime that they're accused of committing. But I think it's important as a treatment provider, as a social worker, to talk about the factors that contribute to mental wellness or contribute to mental illness. And many people believe that the strongest impact, the factors that have the strongest impact on our health and well-being are our individual choices, individual lifestyle choices. Do we smoke? Do we drink? Do we eat? What do we eat? Do we exercise? Those things are important, but what's more important and the primary factors that shape the health of Canadians are not our lifestyle choices, but rather the conditions we live in. And these conditions are known as the social determinants of health. And Canadians as a whole are largely unaware that our health is shaped by how income and wealth is distributed, whether or not we're employed, and if so, what kind of working conditions do we experience? Furthermore, our well-being is determined by the health and social services we receive and our ability to obtain quality education, food, and housing, among other factors. And contrary to the assumption that Canadians have personal control over these factors, in most cases, these living conditions are, for better or for worse, imposed on us by the quality of the communities, the housing situations, our work settings, the health and social service agencies, and the educational institutions with which we interact. And people with mental health challenges are routinely marginalized and oppressed. And negative stigma surrounding mental illness has resulted in exclusion and discrimination of people with mental health problems. And commonly, people who struggle with mental health issues also experience other intersectional inequities: poverty, race, gender, sexuality, gender expression. And these marginalized groups have higher rates of mental illness, and they have decreased access to the social determinants of health. And these are the factors that are absolutely essential to recovery and positive mental health for everybody. The supports that are critical for our overall well-being are not equally accessible for all. And there are many barriers to wellness for those who are struggling with their mental health. These barriers are created and ultimately sustained through all of these oppressive practices within our various institutions in our communities. In a therapeutic court, while we're providing individual treatment, it's really important to also consider the larger systemic issues and the inequities that contribute to mental illness, and ultimately a person's involvement with the criminal justice system. There are 14 specific social determinants of health, and they're important to consider when you're creating a treatment plan or coming up with a plan of action for somebody you might be working with. Income and income distribution is a significant factor in our overall psychological functioning. It, of course, impacts our ability to meet our very basic needs, ability to eat well, have shelter and decent shelter, but it also allows us to access other services and other mental health treatment options that aren't publicly funded, like counseling programs, rehab centers. And low income contributes to not only material deprivation, but it also causes social exclusion and an inability to engage with services that might be really helpful for somebody's well-being. And then when we look at education, education is a key tool for building social capital in our society. And it's highly correlated with other social determinants of health, and very important ones, such as level of income, employment security, and what sort of working conditions we work in. Education's a critical tool to help people move up the socioeconomic ladder and provides access to other social determinants of health that will contribute to wellness. Employment's important not only because it provides people with income that's, of course, critical to survival, but it also provides meaningful day-to-day activity, routine, a sense of identity, a sense of pride, a sense of who somebody is and what's important to them. And people with serious mental health problems are often unemployed or underemployed in low-paying, physically demanding jobs. Finding and maintaining employment is difficult for people with mental health problems. but it's not solely the result of the symptoms that the person experiences, as many would commonly believe. It's a consequence of the stigma and the lack of opportunity that's offered to people who struggle with mental health problems. Adverse childhood events also have a significant impact on our development, and anyone who works in social services will tell you that adverse childhood experiences are a very common theme in the field of mental health and the support we're providing to people. And these experiences impact how we feel, impact how we relate to our community, and how we function as adults. And difficult childhood experiences are more likely to occur when people are living in poverty, marginalized groups, they're isolated, oppressed. And of course, these experiences are significant, and trauma is linked to mental health problems. And then that trauma can then contribute to struggles with addiction and many times struggles with the law or criminal justice system. Even things like nutrition, food, what type of food we're eating, whether we're food secure or insecure. Food insecurity increases the likelihood that a person will suffer from physical illness, nutritional deficits, but it also contributes to feelings of distress and uncertainty and can have major impacts on a person's overall mental health. Same with stable housing. It has a tremendous impact on stability. It's unlikely that a person will be able to thrive in any aspect of their life if safe, affordable, stable housing is not available. Participating in school, maintaining employment, engaging in family relationships, and supporting positive emotional, physical, and mental health is almost impossible for somebody who's struggling with not having enough to eat or a safe place to live. And people who experience difficulty with housing and staying housed and maintaining safe housing are often struggling with mental health problems. But again, it's not because of the mental health problems generally, it's often because of the discrimination that they experience in the rental process and the rental maintenance process. And of course, this contributes to overall housing insecurity, often over many years for a person. Social opportunities, social safety net is really important for our overall well-being as well. People with mental health problems aren't offered the same social opportunities as those without obvious mental health problems. And this is particularly true of people with severe addiction, who are marginalized and stigmatized probably on another level than those with mental health problems alone. And many people feel unwelcome in our mainstream society, and then are missing the social stabilizers or the social supports that are necessary when contingencies happen, when things come up, difficult times or unexpected life events. We need access to people and places that will help us through those times. And people with mental health problems are often isolated and lacking those connections that will help them. Institutionalized racism, of course, also limits access to social determinants of health. People of visible minority, Indigenous peoples have experienced negative physical and mental health outcomes, often, again, due to the lack of access to social determinants of health. And I think we also have to talk about treatment approaches, and our current treatment approaches, most of them anyway, are provided from a Western Eurocentric medical model. And they're lacking other ways of knowing. They're lacking other pieces of information that might be really effective in our overall system, but that might be really effective in providing support to certain groups of people. A really good example of this is looking at the Indigenous culture. The Indigenous culture focuses on the mind, the body, the spirit, the soul, the connection of all of those pieces to contribute to our wellness. And so when we're working with Indigenous people, we're providing support often from that Eurocentric lens, and we're missing the opportunity to provide support that's meaningful, support that will more likely have an impact on their life. And so when you're making these treatment plans, I think it's really think of these issues. Think beyond that individualized lens. Our whole system is built on deficit theory, meritocracy. We have what we have because we earned it. And those that don't are there because it's their fault. They're at fault for their suffering. And we need to look at mental health as an illness, just like any other illness that a person didn't ask for, a person didn't make choices to get to that point in their life. They're struggling. They need help and support, but they need support from a holistic lens rather than just focusing on that individualized treatment option of that individual. And of course, there are other issues that come up in treatment courts from a treatment perspective. I mean, you can't ignore wait lists, lack of services in rural areas, difficulty coordinating services and tendency for places to work in silos. All of those are also really important as you're putting together a plan for somebody you're working with. Multidisciplinary collaboration is a cornerstone of therapeutic courts. And some of the difficulties, though, is that multidisciplinary collaboration means we all look at it from a different lens, and we all have different goals and perspectives and ways of practicing. Even within a discipline, individual professionals will have a different lens and way of practicing. So it's really important whenever possible that teams function as a fully integrated team. Sometimes places call themselves a team, but don't actually work as an integrated team. They work apart, but in contact with each other. And for a therapeutic court to be as effective as possible, that multidisciplinary collaboration is critical. And not only does it support the people that we work with, but it also creates a learning environment and can contribute to the professional growth of all the members on the team. I mean, if I think back to my years in the field, I've learned so much from different Crown attorneys I've worked with, different defense counsel that I've worked with, different judges who have sat in our therapeutic court. We all learn from each other throughout the process. And we, of course, when we're doing that, we provide better support to the people that we work with, which is, of course, most important. And so those are some of the key issues that I think are important from a treatment perspective. I hope you'll consider those as you go forward if you're a treatment provider. And from here, I'll pass it over to Lucy and Christine, who will talk about some legal issues related to therapeutic courts. Thank you.
I'll just jump in, Lucy, and start. Thank you very much for inviting us to be here. We're really happy to be here. Lucy and I work together in different roles, but collaboratively in the sense that we're talking about right now in our mental health court in Brampton. We work out of the Brampton courthouse. And I'm a criminal defense counsel. Most of my work is representing the clients who will find their way into our alternative court. And Lucy is the mental health lead, as it was introduced. And part of what Kim was talking about really resonates with that sense of having a team, because you can put the brick and mortar in place, and we can't even do that these days. But it's the players, the stakeholders who make or break an alternative court. So I'm really grateful that I have Lucy, who's our lead, and I rely on just knowing that she exists some days to keep me going. Our court is not perfect at all, but what I wanted to say about it is that it came to fruition many, many years ago with Justice Catherine McLeod getting together an idea about having, this separate kind of space for these separate kind of cases. And now it's really grown towards a lot of work put in with the Canadian Mental Health Association, our manager there for the court operations, Shelley Schneider, and the team in an alternative resolution court committee put together a lot of effort into developing a goal of what we wanted our court to look like and how we wanted it to be framed moving forward, coming away from the stigma of calling it a mental health court was the first thing that we decided we wanted to change. And so we're now called the Alternative Resolution Court. And we really do try to use that term, ARC, because we're trying not to get away from the idea that, well, it's the mental health court, because of that stigma. And we actually are wanting to broaden, and the vision that's come out of this planning and the Crown Attorney buying on and the judges buying on and the CMHA having the support is to create a space to have access to justice and equity for people who are not the mainstream candidates for the criminal justice system, by a lot of reasons why they shouldn't be there in the first place, but Kim just covered a lot of that. So what are we going to do with this population that is, coming into a courthouse like Brampton, nonstop? And the idea was to create a space in the confines of the box that we're dealing with, because we're all operating in the box. We recognize that, but where in the box can we find some equity for and think outside of the box? So we are focused on the accused in our court in the way that we want to invite people to come into the court, regardless of whether they meet the criteria, have a diagnosis necessarily, or are going to be eligible for the formal mental health diversion or not. And Lucy's going to talk a lot about the options of what I'm talking about, but I wanted to introduce the kind of vision that you need and the players that you need are going to be very important. And sometimes those players can change, but as long as the core vision is the same and there's a model set out that encourages, we are trying to get away from narrowing it from a community treatment court, a drug treatment court, but drug treatment is very different and has to have its own stream at this, time. I recognize that, but my point is the same. It's alternative resolution in some way. It's alternative to the mainstream because people need equal access, and you can't have equal access when you don't have an equal footing. And that's where the equity comes in. So we will have a court that is going to be some people who are just going to be checking in, and the goal will just be to see them once a month and make sure they're okay and get them a ticket for some food at the cafeteria and see if they've connected with the street health worker, because their issues are so big, they're unhoused. Their goal for this diversion is going to be getting them housed, right? And so we welcome people who may be first facing, a murder charge, but their presentation is such that they don't do well in a mainstream court. And we're not going to have the murder trial there, but we want that person and their counsel because of their difficulties and to be in a space that's a little less mainstream, just to set that date even. And so this is Lucy and the mental health lead Crown has a lot of, say in what gets in there. And so it is important that she communicates, and she does, with all the players to get people into our court. And let's see what we can do at their level. And so that's what I love about the alternative resolution court in Brampton particularly, because we have the capacity to broaden it and we have the infrastructure, not enough, but more than other places. So I wanted to be able to introduce the fact that we're a mental health court, a community treatment court, but we're more than that. We understand that there's a difference and that we're trying to think outside the box while recognizing we're still operating in the box. So I wanted to just introduce that. And then Lucy, I was hoping could just give you the structure of what actually happens in the court, what stuff does get in there then, and what's the mainstream, the meat of the court, or the main meal, because you don't have to eat meat. So I'm going to mute and Lucy's going to take over, and she's much smarter and more articulate than me. So
not true at all. Thank you very much, Christine. We're very fortunate in Peel that we do have a mental health court. It's mental health / we now call it ARC. And obviously there is the stigma involved with that title, mental health court. And some people still use that because for a long time that's what it was called. But we're very privileged that we have that. And it's 2 days a week. And on those 2 days a week, we're supported by CMHA, and we have a doctor available on Tuesdays and Wednesday lunchtimes to meet with people to do fitness assessments, which is invaluable to us to keep things moving and to make sure that people aren't in custody any longer, for not a moment longer than is absolutely necessary. And when it became the Alternative Resolution Court, it was because there were other people that needed support. And I think I'm going to narrow it, but actually it is broad because, as Christine said, actually anyone can come into that court that wants to. Like, we won't stop anyone. And once we get them into that court, us as a team, people like Christine, myself, CMHA, will meet with that person and we'll see why do they want to be there? What can we do for them? Is there anything we can do for them? Sometimes there's not. Sometimes it's not the right place and we have to move them back out. But for the most part, it is the right place. So we assist people who have cognitive delays, Alzheimer's or dementia, acquired brain injuries, people with concurrent disorders, mental health and addictions. And we really want to do everything that we can to manage risk for the community, because we're not just there to assist the accused. We're obviously also there, particularly as a Crown attorney, we want to help the public at large. And so we welcome these people in. And what happens when they get in there? So it's only Tuesdays and Thursdays. It runs all day. And what happens is a group of us meet in the morning. Duty counsel, myself, CMHA, and we discuss everything that's going to happen that day. And we discuss every single case that is coming up. And we see, what can we do? Is there anything we can do immediately today? Can we call someone today? Is there someone we need to contact today? Or is this something that we need to get referrals for? And we have that meeting, and then we take time per person and we give them time. And part of the fact that we have our subcommittee on this is about making sure that the judges who sit in there, so it's judges, it's not justice as a piece, they know that this should be a court that allows people, you know, 10, 15 minutes, 20 minutes if necessary, that we can really try and hone in on that person that day. Because as you probably know, people in this community, if we've got them there, that moment, and they're on the phone, they're on the Zoom, they've gone through all those difficulties of getting that technology, and we have them, we want to try and do what we can in that moment to help them. So we do. And in terms of broader what we do, or in terms of what we try to make sure we can achieve, is we offer mental health diversion. So that is for lower level criminal offenses that we really don't think, given the population that we're trying to serve, should be criminalized. And CMHA are fantastic. They have significant funding for this program. And if a Crown Attorney thinks that this person might fit the bill, they pass it on to CMHA. CMHA will meet with them. And then I get emails all the time from defense counsel saying, what does mental health diversion mean? And it's tailored to the individual. It really is. Like, each person has a completely different mental health diversion than the other person. So CMHA will meet with them, and there is criteria for mental health diversion through CMHA, and symptomology, obviously, and they do require that there's a nexus. So if that person fits that criteria, then they will say, okay, well, this person is struggling with housing. This person doesn't have a doctor. This person doesn't have a diagnosis. This person has no family. And they will do what they can to create a treatment program for that person if they fit the criteria. If they don't fit the criteria, though, it's not over and done with, because we as the Crown Attorneys, we do have some freedom, and we do oftentimes do informal diversions. So CMHA might say, look, we couldn't really find a nexus because this person wouldn't talk to us. So we couldn't decide that there definitely was a correlation between what the person's alleged to have done and the issues that they face. But I think we all know that oftentimes the person won't be forthcoming about the issues that they're facing, and they will deny it. And therefore, there can't be any formal nexus. But we can take a back step and say, okay, well, great, you have a doctor. We know you have a doctor. Could you possibly get us a letter from your doctor? And then the doctor might say, look, this person was in regimented treatment for a period of time, and we've not seen them for 6 months. And then, you know, hopefully if they have a lawyer, it can help, because we can have lots of conversations between the Crown and the lawyer about what can we do for this person. Like, they don't fit the strict criteria for mental health diversion, but what can we do to manage the risk? What can we do to help them? And as Christine said, sometimes it might be just check-ins. Let's just keep an eye on this person and bring them into court, have a chat with them, see how they're doing. Things can come up during that chat that we can, as I said, we can try and assist with. And if for a period of time they're calling in, we see, oh, this is great, this person's calling in. They understand that they've got this obligation, they're sticking to this obligation. And even that, as small as that seems, it is some progress, we would say. So we have the formal and the informal mental health diversion. There's no bar to doing it more than once. In fact, many people do it more than once. More don't, in fact, statistically. Most of the time, you know, that interaction with the criminal justice system, and then if we've got all these supports, that might be it for them. But for the ones who come back around, we do find that if they are engaged somehow in this court, then at least there's a period we have that they're not involved in the criminal justice system. And that might be 6 months, it might be 9 months, it might be 12 months, it might be 18 months. But we just think that's a win. And we're very pleased that at least for that period of time that we're all engaged and we're all trying, you know, that criminality has ceased, even if we know down the road it might be back again. So I'm really glad that we don't have that bar, that it's a one-time thing. Aside from the fact that we do those diversions, I mean, it's called the Alternative Resolution Court, and I think that is a useful name because, as Christine said, it doesn't box anyone in and it doesn't stigmatize anyone. But as she said, like, we do have people who have been charged with like homicide in that case. And obviously there's not going to be an alternative resolution for them necessarily if they're charged with something as serious as that. But the actual environment that we all try and create is something that we can achieve the most. You know, we know that people might sing in our court. We know people might swear at us. We know, I mean, I've had it where someone tried to throw a shoe at me. And we all know that we might face that. And so if we do face those behaviors that aren't normal or ordinary in another court, we're not caught off guard, and we can all move on, and we can try and see what we can achieve. So I think when Christine says that we do have the people who they're charged with a homicide, if they're in there, either virtually at the moment or in person, everyone in that court has been trained or should have been trained to know what might come. And we try, and therapeutic is a word used, we try and make it as less like a court as we can. Unfortunately, sometimes, you know, they're in handcuffs and we can't really get away from that. But we try by the way we talk to them, the language that we use, the time that we give them, to de-escalate that stress that is enormous for people that are coming into contact with the criminal justice system. And like, for example, before we all went virtual, we had a needs basket in there, and anyone could come up and just take something out of the needs basket. And we had water, we had granola bars, we had hygiene items, different kinds of food would come along because we had a lot of people that were assisting, volunteering, and giving to that. And that one small thing, I think, did make a difference, because then, and it was by me. So I'm the Crown Attorney, or I'm typically against these people. I don't want to be, but that's obviously how I'm viewed. But it'd be by me, so they'd come to me, and then they'd say, "Is it okay if I take it?" I'd say, "Yeah, please take whatever you need." And that kind of just breaks down those barriers. And I'm really proud that we have a court that we've managed to do that. Aside from the diversion and the just set date courts, that's when you just come and address your matter and it needs to go over for some reason. We also do fitness assessments in there, and that's why it's great that we have the doctor. So we don't have to send the person off. We don't have to wait a long time. The longest they're going to have to wait is from a Friday till a Tuesday. So the doctor will meet with them and see if fitness is an issue. If it is an issue, it's fantastic. We have the CMHA there in the court that day. We try and get we'll do a hearing that afternoon, or we'll try and get a bed if there needs to be further assessment. And that can all be done together because we all know what we're working towards. We also do NCR assessments in there, not criminally responsible assessments. We used to do the actual hearings in there, but we just got too busy. So we're fortunate that we do have some designated mental health and ARC judges. So we can just say, okay, this person, there's an issue. You know, we for sure don't think that this person was criminally responsible. And we have this assessment now that says it. And then we all go forward and we meet together, and we'll do that actual formal hearing on a different day to the Tuesdays and Thursdays. We used to do bail hearings in our court, and I think in time that will come back. We don't do them at the moment, but also as the mental health crown, anything that has that, and I am called mental health crown, I'm not called the art crown, so I hope that doesn't offend anyone. That's the title that I've been given by my boss. But I think you know the role that I have. Any bail issues, where there is an issue, perhaps Alzheimer's or a cognitive delay or a mental health issue, I will get that bail, me and my colleagues, and we will take a look at it, and we will say, we don't want this person in custody, but they're struggling, they've got no surety, they've got no one to help them. And thankfully, CMHA can come up with a release plan to help them. And again, it's tailor made to the individual. So it's looking at what do they need? Do they need housing? Do they need transport right now, today? Is that how we're going to help them? And they'll come up with that plan and they'll send it to me and I'll say, yeah, I think this is a good plan, or no, it's not enough. But we do what we can. So that exactly as Kim says, the last resort is custody for us. Unfortunately, sometimes that is the case. There are people that do go to custody who have these challenges, but you know, that is mitigation. The challenges that they face is mitigation. And we, again, will try and come up with something in a probation that, you know, even if they have to go to custody, when they come out, what can we do? And we all work together to try and achieve something positive.
And I'm going to jump in just to say, to echo what Lucy's saying, to say that that is the lens that the Crown is coming at it from, is how can we do things differently? And that's the lens that matters in an alternative court, like in anywhere you are, is what is the lens that you're looking at it. And it isn't all like lovey-dovey and, oh, you know, we're handing out the knapsacks and all that. Like, you know, we're not patting ourselves on the back because we're having this fluffy little court. We're really actually, you know, trying to also do the business of the court and deal with people's court cases. But we want to provide, like Lucy's saying, like I said, an atmosphere that allows people to be heard and to be human, because everything has been so dehumanizing in these people's lives, in many of the people's lives already. And I know we're running out of time and there's going to be questions, but I just wanted to say at this time in the global pandemic, it breaks my heart that people are asking for bench warrants on somebody who's got no fixed address, who's been in alternative resolution court 1,000 times. Like, right now is when we need the most compassion and the least reliance on custody, because our clients' lives have not gotten any easier and have gotten even worse. And everybody who's listening is here because their lives understand that in some level. So right now in this day and age, I mean, being unhoused, being unfed, being unmedicated, being untreated, having no access to resources was always the problem. But now it is more of a problem than it ever has been for our clients. And so now is the time when we need to step it up and be more amenable and more open to change and to looking at things differently, because it's certainly not the accused's fault that their resources have just been decimated in a pandemic and they've been left to fend for themselves. So I mean, I guess there's a lot that we could talk about, but I think it's important to understand the underpinnings of why you're in that court. And if you can have a collaborative approach and you can have somebody looking at it with the education and the lens like a Kim Briggs, or somebody that has the power to determine what's going to happen with this case, like Ms. Rasmussen, who is, that's where we want to come to, a place where we can all come at the table and say, what are we doing here? What is the goal? And if that person doesn't want to be in that court, they can leave, because they are also a person. They also have legal rights, right to representation, a right to choose whether or not they want to engage in a program, a right to choose whether they want to be in an alternative court, a right to go to trial, a right to put up a defense that might be shit, sorry. But we also do that in that court. So it isn't a fluffy court where we're handing out prizes in any way. If we're dealing with a case that's a serious case, we're dealing with that case, but it is a court that looks at things through a different lens, to try to make the world a better place, because something's got to give. This system is not the system that we need for anybody in the community. So I'll stop talking now because there might be questions and we've been rambling a bit, sorry.
We all enjoy the ramble. We do have a few questions. I'd like to remind everybody as we move through this part of the webinar that you can put your questions in the Q&A or in the chat. We're monitoring both. So the first question is a nice lob ball question I think we can get through is, what are the formal and formal diversion lengths? And are there any charges that are excluded, presumptively excluded from diversion?
Yes, there are quite a number of charges that are presumptively excluded. It's probably easy to go with the ones that are included. So domestics are presumptively excluded. However, it's not completely prohibited. So a domestic mischief we might have as a diversion. A domestic utter threat we might. It'd be more challenging for us to justify an actual allegation of an assault. So the ones that are presumptively admissible, though, let's take away the domestics, would be an assault, utter threats, criminal harassment, mischief, property offences. They're presumptively admissible. Then there's a bunch of cases that are presumptively inadmissible, and then there are ones that are for sure not ever going to be a diversion. So I think you just be logical in terms of the more serious it is, kidnappings, aggravated assaults, homicides, manslaughters, they're never going to be in that. Terrorism, they're never going to be in a diversion court. But we do sometimes have robberies. So like a low level robbery might squeak in there. But again, we just look at each individual case on its merits and see what we can do. There's no length, actually. A typical mental health diversion with CMHA would be between 3 and 6 months. But we have, on occasion, we've had ones that have gone on for years, like up to 3 years. And at the end of that, then we've put them on a 3-year common law peace bond. So like really for 6 years.
What she's talking about are the robberies that are not supposed to be there, but do find their way. She has to be diplomatic. She has a boss. I do not. But when you have a challenging case, but there's a nexus and you just like, don't give up. Like, there are things that can happen sometimes. And so when you have those robberies where it's like, I'm homeless, I have nowhere to live, and I think my family is going to be kidnapped right now at a bank and they're passing a note. Well, that's technically a bank robbery, but we all know why that happened, right? So those are the 3-year show up, stay out of trouble, keep on, in this case, your meds,
Stop giving notes to bank tellers.
Don't go into banks with notes, asking for money and promising you'll pay them back. But what do it's a bank robbery, technically. So you can do this whole 3-year thing and then a 3-year common law peace bond where they don't, those things can happen, but you have to, know your crowd.
I've seen a lot of variation over the years, really dependent upon which jurisdiction you're in, as far as who gets in and who doesn't and what their criteria are. And I think that really speaks to the importance of that consistently staffed court and people who have a lens that understands mental health challenges and developmental delays and addiction and other challenges that people run into, brain injuries, because you're going to look at things differently than somebody who doesn't have that lens or that experience or that training. So that, I think, is one of the key pieces of developing a community court, is making sure you have the right players. A Crown, we were lucky enough in St. Thomas to have a Crown who's recently been appointed as a judge now, but he was also a Master of Social Work. So he had his law degree and a Master's in Social Work. So he was a great fit because he had education, training, and experience in both aspects of things, right? So training and education is going to be important for the people who work in the court, judge included. That's a really important piece for a successful court, in my opinion.
But also can I just add, though, for any Crown attorneys out there, there is, in the Crown policy manual, there is actually a literal criteria of the inadmissible, presumptively inadmissible, and presumptively admissible. So you can look at that yourselves to say, okay, which category are you in?
I have a question. Thank you, everyone, for your input so far. And it's directed at Christine, but I wouldn't mind feedback from all three of you. And it's a question from an anonymous attendee on the board, but it was exactly what I was thinking. This is a struggle that I've had from a legal background, but also as a social service worker. So on that theme of MSWs and a lot of our audience today who may not have a legal background, I'm conflicted with the tension between client advocacy versus NCR hearings versus when is the right call for a judge to make an order for treatment, for first of all, for fitness, and then possibly even a treatment order? When are you doing right by your client by sending them into the institutional system when maybe more client advocacy on the front lines would be beneficial? And how do you make that judgment call, Christine, or others?
I would, thanks, Andre. It's a great question, and it's an important one for a defense attorney to answer, I would say. And and that is what we are when we're defending clients who are in the criminal justice system. We are lawyers. We aren't social workers, although, you know, we might, you know, appreciate that area. I need to put on my defense lawyer hat, and I need to say, let's get this person a bail. Let's get this person out. So when fitness issues are raised, though, if you're the lawyer and you're having trouble getting instructions from your client, and you're not sure they're understanding the nature and the proceedings of the proceeding, you have to assess that, and you have to advise your client on, like, do you want to proceed with the bail hearing today? Are you feeling well enough? Or would you like to put it over till tomorrow? Because ultimately your client is the one who gives instructions. We are not, and I said I'm a client-centered lawyer. That's actually my job. I have to take instructions from my client. So I've been in the position where I might think they're NCR, but I'm not. I give my clients always every option because I'm a lawyer. I need to. I'm giving them advice, they're instructing me. So when I see the range of options, and I think NCR might be a factor or might be something the Crown's raising, I'm going to say, on the spectrum of your choices, trial, guilty plea, assessment, they might raise it. We have to be aware of that. But if they say, I don't want to plead NCR and I want you to fight it, that's what I got to do. Because I'm not here to save the day or the year. It's not that's what I mean. It's not a touchy-feely court. We have those moments, great. But this is a court of law, and that person has an individual right to legal counsel and the same respect in the system that everybody else does. So it's a very fine balance of when you see somebody that's not presenting well, I wouldn't raise an issue of fitness unless it was very clear to me that they were clearly unfit. And even then, I don't need to raise it right away because I may not be engaging in a legal proceeding at that time, and I might not be entering into a bail or a plea. So I may not have to raise it. I may want to see if they can stabilize, fitness fluctuates. So it's a very fine line as to when you advocate and when you, and sometimes those lines can be blurred and crossed, but as a defense counsel, as a lawyer, I have professional legal ethics, to abide by as well. So I take my instructions from my client, and I think that it, frankly, is your job to also raise an issue when it's appropriate to, and when the law says you should. But everything is a case-by-case basis. You have to assess it at the time. And the more that you have the people that you're familiar with, like Kim is saying, you get to know these people too. And you could say, like, I'm thinking maybe he just needs a couple nights, he'll be better. Like, we can get this done. So it's always about evaluating them from the perspective of the fact that they have the same rights and the same access to justice, or should have, as others. And so let's treat them at that starting point, as opposed to wanting to be like, patriarchal or, want to save them or anything, I don't know if that answers the question, Andre, but.
Yeah, that's amazing. Thank you. Thank you so much. Couldn't see my feedback, but I was nodding.
Oh, good.
Yes.
Jen's on. Jen, you're on. Yeah. You were on mute too.
Thanks, Christine. Yeah, I saw that. Another question we had that came in on the chat from Phil. I'm not sure who wants to handle this. Maybe a combination, and I'm sure it doesn't relate specifically to the Brampton ARC program, but to any I'll call it ARC program that is around. But what role, if any, does peer support play in these programs?
I'll take that one, I think. If I'm going to be honest, I'm going to suggest that not a big enough role in most ARC courts across the province. I think that that's an area the whole mental health system has not really picked up quickly enough. There's a lot to be said for lived experience and other people, natural supports in the community, providing support to people who aren't necessarily paid through their profession to be there. And those are great supports. And so I think that's something that probably should be built into most programs. And there's probably some out there that do a great job at that. I'm working on helping to develop a drug treatment court in Elgin County. And that's something we just talked about, how we're going to work a peer support role into the entire court. So that will be ongoing, weaved right through, because I do think it's something that we need to turn the lens onto.
Is that something to Lucy and Christine that you guys have contemplated in Peel specifically?
No, but now we know Kim's working on it. We're
Yeah.
we're going to be emailing her for the model.
Yeah.
Because I say, bring it. We need more support, more resources, more collaboration than we ever did.
Yeah. Yeah. Okay. Do you want to add anything, Lucy, or no? Not on that one.
No, I don't need to add.
Okay.
I agree with Christine. No and yes. No, yes, we want it.
Yeah. Okay, we've got a question from, says McGregor Austin Olson. So it says, what organizations, meaning governmental or NGO, do you see as necessary regarding buy-in in a community that is interested in developing these types of programs where they don't already exist?
I can take that one too, if you like. I think there are several players, and I think that, again, is a key component of the success of any program. You need to have professionals from throughout the community that have different lenses, different approaches, and different resources, different funding pockets to be able to provide support to people. So, I mean, of course, your critical supports are going to be your mental health organization, your addiction services, your Crown Attorney's office, the judge that's going to sit in the court, your local defense councils. You're going to need, those are going to be your immediate players. But then you're also going to need support of your local police service. For example, we got a ton of great referrals from our local police service, and that had to come through that buy-in piece, right? We had to educate them on why our court was helpful, why it was a good thing. Because traditionally there's been attitudes, that it's a touchy-feely kumbaya, is this what we should be doing, right? From some groups of people. And so that's part of it too, is educating the community on why these courts work, and why we should be investing our services and our supports and our resources to a court like this, ultimately to have an impact on our entire community, right? And of course, the recidivism rate, but improving the wellness of the individual people that we're working with.
To follow up on that, I had a personal experience with that with one of my clients in a certain downtown core, where that client was historically seen as problematic by the police. That client was routinely surveyed to be picked up at the earliest opportunity they could to arrest him. My client also suffered from a degenerative disorder and addiction and other issues. And it is not his fault that he's been charged with mischief for having defecation on his pants in a stairwell. So what I did was not give up and push it to the inspector level and said, why don't you get the city of Brampton to figure out how much they're spending on security, to monitor him, to arrest him, and everybody and the system is going, why is he in jail? Like his defecation is down his leg, he, like, what is going on? And this is happening over and over again. And I just grabbed Lucy and said, this has got to stop. And like, what are we doing? He's a nuisance to you. Why don't you balance the money? And to his credit, the inspector and the security guy was like, yeah, this isn't really working out very well, is it? Like the hundreds of thousands of dollars that we are spending to prosecute somebody who is hungry and has nowhere to live because we don't like them, because they're a bit mouthy with us. He's a bit ornery. I get along with him really great. I wonder why. Anyways, let's do the ways and the pros and cons here. Let's use their language, and let's do a cost benefit analysis. Like, we all know that the problem is money and the resources, And like Kim said, we're all operating in these silos. So I'm like, okay, Lucy, convenience store guy who he robs from all the time, theft, not a rob, you know, police, like, what are we doing here? Right? Why not, instead of arresting him, why don't you take him to the shelter or to the hospital to get some medication or something? Like, we got to think outside the box. So you can really, you know, push that as well when you're in a court like that. I don't know where I started on that, but it was important at the time.
I think that speaks to the bigger issues of equity though, right?
Yeah.
And all of our system is very reactionary. We're responding to the issues as they arise, and we're forgetting the prevention piece. And we need to start with the social determinants of health in children, in youth, and
Yes.
making sure that babies, toddlers, children, teenagers have access to these services that will keep them well, which then impacts the likelihood that they're going to be involved in behavior that is likely to lead them to charges, right? So,
and grabbing in those other community players like the
That's right.
police, like
Yes.
the security system for the city of Brampton at the bus shelter, you know, like, let's just talk to them. Let's just figure this out. Maybe we can, maybe we can't, but we need to talk because this is not working for anybody.
I'm going to jump in, even though I really don't want to wrap up this conversation because it's really important. And but I can say that this is Mental Health Month that we've named it at the AJTP Mental Health Month. So we have 2 further webinars coming up later on this month. One is on March 23rd and one is on March 30th. So I really hope that you're able to come back and join us for those, where we're going to continue these types of discussions that are very engaging and informative. If I could take a moment to thank our fantastic panelists, Lucy, Christine, Kim. This was amazing, really informative, inspiring, and I think it's the beginning of a conversation, not the end. So we're really looking forward to what we can continue to do together moving forwards. I do see that there are a lot of other questions in the Q&A and in the chat. Thank you so much for those. I am going to change my name to my email address, and you can feel free to send me these questions via email and I will get them to our panelists and we will get back to you as quickly as we can. We don't want to not answer your questions, but we're running out of time. So my email's there. I'll leave my screen on for another minute or two. Feel free to write it down and I will pass the information along. So thank you very much.
thank you very much, everyone. Have a good afternoon.
Bye. How do we stop recording? Christine, I'm going to call you.